Collaborative. We're just going to wait a couple minutes as people enter. We had a large response for this webinar. Thank you to our city partners who are attending and our other stakeholders or clients. We'll give it a minute before we get started. We're going to be talking about next steps for commercial tenants. I think we can get going.
We're good to go.
Okay. So I'm just going to do a quick introduction, Jahi.
Yeah, you're good, Claire.
Okay, thank you. Again, my name is Claire Brelio. For those of you who don't know me, for those of you who are new to our community, I am the Economic Development Collaboratives and Small Business Development Center's Business Disruption Resource Director and Communications Director. And if you are, again, new to us, we've touched over 14,000 businesses since COVID began last year. We're going to be talking about next steps for commercial tenants, but just a few housekeeping rules here before we begin. Everyone is muted and you're not able to use your video, as I'm sure you're already aware. This is being recorded. And don't worry if you don't get all information. We will be sending out the recording as well as the webinar, potentially webinar notes, but definitely the PowerPoint presentation after this. We had a large amount of people register for this webinar, so we're very thankful for everyone who's joining us. You know, one thing that I just want to mention is that if you're new to the EDC community and the SBDC community, we provide free consulting services to small businesses. It's completely free. You will have access to the small business advisors that I will introduce in a moment after this webinar, if you would like to talk with them further. But I would say one of the common themes since COVID began, and especially in my role as Communications and Business Disruption Resource Director, is getting consistently asked, you know, what do I do? What does this mean? What does this mean for me right now? How on earth do I interpret this new program, PPP, whether it be an eviction order or moratorium or whatever the case may be? This has been a confusing time for a lot of people, and we're here to help guide you toward the best path possible. And lastly, I want to say before I turn this over and make a formal introduction of all of our panel, you know, disruptions sometimes come to clear paths. And we've seen that a lot with the businesses that we've worked with that are reworking their business models now, that have had to pivot their business model, that have had to make a change midway through the year because their supply chain got cut off or whatever. So disruptions can clear paths for us, but they can also put us on the right path. And in this extraordinary moment in the last 3 years in Ventura and Santa Barbara County, we have been through disruption after disruption after disruption. And we are now seeing a lot of business owners make positive changes towards the path that they had wanted to be on from the beginning. So I want to encourage you, if you're here, we're with you. Lastly, just to mention, we have a Q&A feature located at the bottom of your screen. This is only to be used for questions. If you're having technical difficulties, please choose to use the chat feature, and a member of our team on the back end will help with that. And please withhold your questions until the very end. You will have the opportunity to go through questions. So we will have the opportunity to go through questions at the end. So don't worry if your question is not addressed during the webinar. So with that, I'm going to share my screen and we will move right along. So we are talking again about next steps for commercial tenants. And this has been a topic that we have been requested by our stakeholders, by a lot of our clients. You know, can you do a webinar about this? The answer is yes. Here we are today. And I hope this brings some clarity on what is happening. Sorry, my screen just went blank again. I'm gonna reshare my screen. This is like my 50th webinar, and you would think that things would work by now, but hold on one second. I'm very, very sorry. Now, why would this not be working? We're gonna start in another way. Hold on. Okay, can everyone see my screen? I'm your lovely host. I've already talked about myself, but I have been an SBDC advisor for the last 8 years. And so I've been through several tours of disruption, as have our lovely panel here today. Bill Bartels, one of our most, I was going to say something else, Bill, but one of our most trusted and senior advisors, our EDC SBDC advisor, Bill Bartels, has lived and worked and been this work as an SBDC advisor for nearly, I don't know, how long has it been, Bill?
11 years.
11 years he's been with us, and it's pretty remarkable. His family owns a farm in Fillmore, and he works with generational family business dynamics and anything under the sun. So we're very happy to have him on our panel today. Erica Bristol is an attorney and a commercial mediator. She is one of our ADC SBDC advisors as well. Thank you, Erica, for joining us. And without her, I have to say this webinar wouldn't have happened. So thank you so much for you. Gonzalo Fernandez, love Gonzalo so much, one of our ADC SBDC finance advisors, and previously grew up in Havana, Cuba. And so he has a wide background in financing and the banking industry, and he's a tremendous asset to our center, speaks English and Spanish. Gonzalo, we're so happy to have you today. And last but not least, Anthony Curtis Elliott, described as a forensic accountant. He is a CPA. He is an expert in all things finances. He might argue with me about that, but I don't care. A well-dressed man, and has clients all around the world. We love Tony so much. So thank you all for being here. We are happy to talk about this topic with you all. So if you haven't heard, as of last Thursday, actually, Governor Newsom threw a little curveball at us, which some of us anticipated, signed an executive order 3021, extending authorization for local governments to halt evictions for commercial renters impacted by COVID-19 through June 30th, 2021. And of course, the former date was March 31st. And so there we go with our first unknown. How is this going to impact us? What is this going to do? And at this point, I'd like to turn it over to Bill Bartels.
Thanks, Claire. Good afternoon, everyone. So challenges for both landlords and tenants lie in the declarations of moratoria, and as many layers of the local ordinance that have been enacted over the last year. Interpretation and application of each varies by jurisdictions. Not all local governments have adopted a current moratoria ordinance. As an example, the governor's March 4th executive order is of value if there is a local ordinance in place that authorizes, as allowed, the extension through June 30, 2021, the halting of evictions for commercial renters, and applies to your business situation. The application of the order will vary by jurisdiction. The specifics of where you're doing business and your lease are critical. Today, we're going to talk about three concepts. The first is tenancy. This is a contract by which the owner of real property, the landlord, grants exclusive possession of that real property to another, the tenant, in exchange for the tenant's periodic payment of a sum, the rent. The second is the lease, the agreement on terms and conditions. And the third, unlawful detainer and eviction moratorium. Unlawful detainer is when a tenant detains or occupies the landlord's property without paying the agreed rent. Eviction is the process of forcibly ending the tenancy. Think sheriff showing up. An eviction moratorium is an unlawful detainer moratorium. It is an act that suspends the process of forcibly ending a lease or tenancy. Every case of tenancy is based on the specific facts or terms. The lease agreement between you and your landlord will guide specific options and areas of negotiation for moving forward. This means communicate with your landlord. Next slide, please. In this challenging time, it is critical to begin with a moment of care. Take a deep breath. Walking through this is a series of steps, one specific step at a time. So let's turn to those specifics: the what, the where, and the who. What is your business? Where is it located? What are the agreements that allow that business to exist? What are the elements of your commercial lease? What does that lease say? Who is the lease between? Who's the landlord? Who's the tenant? Let's look at the current realities of your lease. When did you last pay rent? Are you current? Have you communicated with your landlord? When and how did that communication occur? Each of these questions need to be addressed by you as the tenant, one step at a time. Next slide, please. There are many different layers of law impacting our daily lives right now. It's very important to know specifically where your business is located and what layers of law and restriction are in effect for you, your business, and your landlord. What is the current status of your business? As the owner, do you have an idea or vision for next steps? Review again the current lease. It is a contract. What does it say? What are the terms? Next slide, please. Now, each case is different. Each case is fact dependent. Check with your local jurisdiction to see what the COVID status is and how your lease may be affected by any local law halting evictions for commercial renters. If a local ordinance or authorization exists under most, you must have suffered a COVID-related substantial decrease in household or business income. You must be prepared to prove your hardship. You must not assume you're automatically protected. Most ordinances require that you notify your landlord in writing that you cannot pay rent. You're still expected to pay eventually, so negotiate with your landlord. Generally, landlords can serve notices and file eviction actions. You must be prepared to respond in a timely way to those notices. Next slide, please. Remember, in writing generally includes emails or texts to your landlord. Keep them as a record and request written confirmation that your landlord received your notification. This is one step at a time. There are two additional resources that we'll put in the chat. These are ways to keep track of moratoria, and then for those who want to read deeply, the Department of Real Estate's handbook on landlord-tenant. Next slide, please. Sifting through disaster damage and making decisions is hard work. A year ago, a disaster was declared, and now a year later, we're still in the slow roll of that disaster. The recovery or transition out of disaster has not developed as with a short-term event or incident. Emotional capacity is incredibly important. You can only help yourself if you have the emotional fortitude and emotional resources. You are a resource to yourself. To assess and support your capacity and to make room for the challenges of being a business owner, you need to build strength for the journey. This is emotional capacity. Resources of support are available, and Claire and our team will lay them out as we move through the presentation. Thanks. Erica?
Hi, good afternoon, everyone. No matter where your business is at this time, if you are paying rent timely and you have a good relationship with your landlord, if you haven't paid rent for quite a while, under the protections of an eviction moratorium. If you're just recently being late on rent and you're starting to be concerned about the viability of your business, it's always a good time to conduct a commercial lease clause assessment. It's important to know your lease terms because it will help you prepare for your discussions with your landlord, along with the advisors at the SPDC. And if you need to seek legal advice and assistance from legal counsel, it's great to have certain clauses at hand and highlighted so they're easy to find. Next slide, please. Thank you. So what is a lease? A lease is a contract, right? A contract is an agreement to perform certain terms that's enforceable by law, right? The parties are the landlord and tenant. So you need to determine the rights and remedies and the duties of the parties, both the landlord and you, right? And so it's important to go through the lease and determine what is the landlord's rights and remedies. Very often our clients haven't had the opportunity to read the lease if they've ever read it, and they don't know these clauses even exist. So we want to make sure that you have some information about clauses to look for. We can't give you legal advice on how they will affect you legally, but I can give you a basic information of what these clauses are and things to look for. Before you look at these clauses, you have to find your lease, right? One of the first things that we advise you to do is find it. Very often you may have received a copy via email. You may have amendments. You may have been there a long time and you don't have it all together. You may have a separate personal guarantee. You may have exhibits. Find all of the elements of the lease. The original lease that's signed by both parties. You want an executed copy, not any drafts. Any amendments to the lease, your personal guarantee, your exhibits, any related documents and contracts that you signed when you signed your original lease. It'll be very helpful to have all those things together so you don't have to scramble to look for them if you need to. And that way, if you're talking with an advisor or if you're talking with legal counsel, you have it all together. And in some cases, you may not have a lot of time, and so you don't want to waste time having to hunt through 5 or 6 years of emails trying to find your lease. Find all of the pieces and put it together. And then look for certain clauses in your lease. So now we're going to talk about certain particular clauses that you might want to look for. First, probably the most important clause is something called events of default. What does that mean? Default means a failure to perform something that you promised in the lease. So the events of default clause normally will say, in the event of default, meaning if the tenant doesn't do A, B, C, D, E, what rights does the landlord have, right? And so, thinking of commercial leases, we often are thinking of unlawful detainer and evictions, but there may be other rights that the landlord has under the lease if you fail to perform. The lease is a contract, right? And so the landlord, if they are stopped from evicting under the commercial eviction moratorium, they might want to just seek breach of contract and seek back payment of rent. We've heard that some landlords just going into court and seeking that, right, as opposed to eviction. So take a look at the events of default. Most often there is a failure to pay rent is an event of default, and there may be other things that the landlord could do. Sometimes it's failure to maintain, that might be an event of default, failure to maintain the property, failure to maintain insurance. Sometimes an event of default, if the tenant fails to pay rent, there may be a clause that says all the abated rent has to be paid. All the discounts that you got in the beginning of the lease must now be repaid. So you really want to know what is under the events of default. In connection for that is a personal guarantee. What's that? A personal guarantee says that if the party to the lease does not perform, you as an individual are promising to step in and perform. So if the lease is signed by your corporation or an LLC and it's a new business, very often the landlord requires you to sign a personal guarantee saying that you as an individual will pay the rent. You want to know if you've signed a personal guarantee. That could create personal liability where you may have thought it was just your LLC or your corporation. Sometimes the personal guarantee may be skillfully drafted. Sometimes they're limited in time for just a couple years and they fall off. Sometimes it just says non-payment of rent, so you're not responsible for everything else in the lease. Find your personal guarantee. You'll want to go through and see what you're promising to do if the corporation or the LLC defaults on the lease. Abandonment. Sometimes tenants throw up their hands, they can't pay, the business is not going to reopen, and they feel they can just walk away. Very often there's a clause in the lease called abandonment, and it's also a concept under law. But if you contractually agree to certain things, you need to know what those consequences are. So sometimes it may say on abandonment, the landlord can come in and remove all the personal property and may be able to do other things, allow other people to come in. Make sure you understand the terms under the abandonment. And if you need to get legal advice, you understand the legal consequences of walking away. They could be significant. Another term is force majeure. This is a term that we've heard thrown around a lot. What does that mean? It means an act of God. So in the context of your lease, it will mean if there's an act outside the control of one party or the other, such as fire, flood, earthquake, something outside your control, your failure to perform due to that act will not be a breach of contract. And so you'll want to look and see if there's a force majeure clause. It's not clear if you can use this for a virus or a pandemic, but sometimes the terms are so broadly written that maybe there's some wiggle room and you can talk with legal counsel. More often than not, there will be drafted in this clause something that says tenants' non-payment of rent is not a force majeure event, so you won't be able to use that, right? But still point it out, find it, flag it, have your, if you need to talk with legal counsel, have them take a look at it. Next slide, please, Claire. Options, right? So very often in your lease, there's an option for additional lease terms. You may have a 2-year option, a 5-year option to renew. But in your lease, it may say, so long as you're not in default, you can exercise your option. So if you want to continue staying there, but you're in default, can you even exercise that option, right? You'll want to see where you are in your lease. And if you're close and you're thinking about exercising it, is there something that's going to hold you back? And so you have to consider, what can you do to still have that right, to exercise the option? Or is that right been taken away because you're in default? That can be really significant if you want to continue staying there, and now you may have to move because you can't exercise that option. That means the lease ends right at the end of that term. Holdover, that's a very common clause in a lease. It's when your lease term has ended and you and the landlord have not necessarily negotiated a new lease. So under a holdover clause, it usually says if the tenant's still there and the landlord's taking the rent and agreeing to accept the rent, then your term changes. It's usually not a 1-year or 3-year or 5-year. It usually changes to like 30 days or 60 days. What does that mean for you? Well, if you're technically in a 30 or 60-day lease, the landlord could try to terminate based on a 30-day notice, right? And if you have significant materials or personal property in that space, can you get out within 30 days, right? So it's important to know, are you in a lease? Are you in a holdover period? I've actually had a couple of SBDC clients where the landlord has tried to send a 30-day termination notice, not saying the tenant has not paid rent, but just simply terminating based on the new lease term, right? You're in 30 days. Normally the law says you give a 30-day notice. So if you're in a holdover period, consider that, because your lease term may be 30 days. Now, if you haven't paid rent and maybe the landlord has sent a termination, maybe that's possibly an end run around the eviction moratorium. That's something that you need to speak with legal counsel about. Dispute resolution. So if we're not in the unlawful detainer and the landlord is looking at you're not paying rent, are there any requirements for how disputes should be resolved? Can you go to court? Must you negotiate? Do you have to go to mediation? Do you have to go to arbitration? Both you and the landlord, right? For things other than unlawful detainer. Point that out, flag that. That might be important to know. What are the steps, the next steps? It may not be going to court. It may be another process. Attorney's fees clause, this usually means if a party goes to enforce their rights and they are successful, I'm really paraphrasing here, they'll recover the fees that they paid their lawyer. Normally in the American system, you don't get those fees unless there is a statute that says you do, or maybe there's some other reason that the court will order them. But this is a contractual agreement to get them. So if a landlord is just seeking unpaid rent, do you also have to anticipate paying the landlord's fees to go to court or even to try to negotiate that, right? So highlight that. And any other rights the landlord has on tenant default? Are there any other things that the landlord has a right that you need to know about in the lease? Think about any other clause that might restrict or change your rights or duties in that space. You should also be aware, and if you need to talk to legal counsel, whether the landlord is in default on anything, so you can tell your lawyer that. And these clauses are really good for you to consider your options. You may want to put a little flag or a little sticky, or you can even highlight them because they're easier to find. Some commercial leases can be 30, 40, 50 pages long. And so flagging these or highlighting them makes it really, really easy to find. And knowing these terms will help you understand your legal position, in light of any eviction moratorium, other rights the landlord may have, and it will put you in a better place when talking with the advisors, or if you need to talk with legal counsel, your legal counsel will be very happy if you flag these things, and also when negotiating with the landlord. So these are some vital clauses that you should very well know about. Thank you, Claire. I think that's it.
Thank you, Erica.
You're welcome.
Tips for negotiation, Gonzalo. We'll have to unmute you, Gonzalo.
Okay, thank you. Sorry. Glad to be here this afternoon to share some thoughts with you. I tell you, in my 50 years experience in banking/lending, I witnessed many negotiations. So I learned what works best, and that is that for the two parties, find a mutually satisfactory solution. It is not a one-way street. That is not what it is. As entrepreneur, keep in mind, although you may not realize that you are negotiating something every day in your business, negotiating a sale, negotiating with a staff that might be performing and not performing, that wants to come in, with vendors, with lenders. And even I can include family matters that how difficult and challenging it is for you to pay attention to both. Keep in mind that whatever you are in negotiation, keep this, settle for victory. Now, settle for victory doesn't mean is to put the other person down, is to find a positive outcome. Okay, emotions are going to kick in. Bill talked a little bit about that. You're an entrepreneur, so you are competitive. And as a competitive person, your emotions are gonna come in and fight you. Focus on what would be a good outcome. What is victory for you? But victory for you does not mean defeat for the other. So the most important thing is you got to be prepared to get into the negotiations. Don't go unprepared. As Erica was talking about, know your lease. Okay, know what the terms and conditions. If you need some advice before you go into a meeting, be aware of that. Make sure you're dealing with someone who has the authority to make decisions. In some properties, you're dealing with a property manager that is not the owner of the property. So be aware of who you're dealing with, and that way you have to arrange your presentation. My recommendations, try to get to the person that is capable of making the decision. Keep in mind, the landlord is also under pressure. He or she are negotiating with the bank, okay? And the bank in many cases are gonna put requirements on them. Like I said, you gotta bring this from your tenants for me to accept that you have a difficult situation, what is called today an economic injury, for you not being able to make the payments the way you're supposed to be. So they are also looking, landlords are also looking to arrange what is known as a forbearance or a restructure of a debt with the bank. So they're going to need your information to do that. You need to define the number of options that will work for you. If you have only one option in the negotiation, you are demanding. Demanding is not the best way to be in the negotiation because you're not giving the other party anything to work with. So you got to come up with options. Keep an open mind. There is a number of options to reach your goal. The other party may suggest approaches that did not occur to you. Stay open. Keep an open mind. Don't go say it's either this or that, period. Communicate, communicate, communicate. God, I cannot emphasize that enough. And communication is not only verbal, it's also visual. It's your body language. It's your tone of voice. It's a lot of things involving the communication. Once you stop talking to the other party, there is no hope for a positive outcome. So communication must remain open. They are not going to get better just because you're ignoring each other. Avoid derogatory remarks. Keep focus on the objective. That's very important. This is what you want to accomplish. And so you keep an eye on that. Look for quick solutions. I tell you, a quick solution probably is less expensive than being in a litigation on something that is more involved. And not only is the money, it's also keeping you away from running your business, which is how you're going to make the money. So you want to go back to run your business. You want to resolve this problem with the landlord, and you want to get back into business. Otherwise, you're not going to make the money that you deserve to make. Don't take things personally. The other party might propose approaches that you find insulting. Take a deep breath, lay back, okay, and come back. I always like to use what I call the tennis game. When I have a very difficult situation, I put the ball back into the other person's court. For example, you're telling me this. What would you do if you're sitting in my chair trying to run a business? And that gives you time to think. That gives them time to think. So don't overreact to a situation. So put your feelings aside. Keep in mind what I said before. You want to resolve the problem. Look for win-win solutions. The best deals are achieved with both sides coming away with a positive, not perfect, outcome. Remember that settling for victory does not mean the defeat of the other party. Look for a positive and yet realistic outcome. And that will take us into the next one. Okay, financial assessment. You can move to the next slide. Since I'm gonna, Tony Elliott and I will share this presentation. The first one is, I told you before, be prepared to go in. You got to assess the financial condition of the business to determine if resolving the eviction issue is going to make a material difference on the survival of the business. You need to know that their businesses, that don't matter what you do, they're already in trouble for other reasons, not only for the rent, but for other reasons. So you got to determine what is that, and it's not profits. Remember, and we will be talking, Tony and I will be talking about in here, there's a difference between profits and cash flow. Profits don't make the payments. Cash makes the payments. Okay, so if you need assistance, our SBDC group, I apologize for that, is here to assist you in making an assessment of the financial condition of the business. That assuming that up to this point there have been no negotiations with the landlord, identify financial options available to commence the negotiations. Bill touched on that. So and again, it's part of the preparation. You got it, and you got to be willing and prepared that you may have to disclose some financial information that you in the past you did not want to do. You need to convince the landlord to give you a break. And to do that. He or she have obligations. Remember that. Keep items about the financial picture include, the cash flow, the sales performance, the liquidity of the business. The liquidity is your current assets minus your current liability. How much liquidity is in the business? What is your debt capacity, if any? Like, for example, if you're going to negotiate with a landlord and you're going to put some debt into the business might not be able to support that debt. So don't commit to something that you cannot do. Conditions with debt holders, including vendors. You don't want to pay a landlord, okay, if you're going to sacrifice the vendors, because you're going to have another problem. Taxes, payroll obligation. Those are three very important aspects of running a business. Tony, it's your turn, my friend.
Good evening, and great content from the EDC team. Remember, we're here to assist you with navigating through challenges with COVID and your landlord lease issues. So starting assessing your financial picture, where does that begin? I'm going to say it begins with consulting with your CPA, accountant, bookkeeper, or other financial advisors, and updating your business financial dashboard. Next slide, please. And so as part of that process, you're going to review historical pre-COVID business profit and loss statements, cash flow, and tax returns. That's an important process. And organizing the records, reviewing them, and comparing those historical financial results with your current financial results gives you a better idea of negotiating positions going forward. And before meeting with your landlord, consult with your financial advisor, or schedule a session with an EDC business advisor and map out a financial plan and key lease negotiating strategies going forward. Next screen, please. And back to you, Gonzalo.
Okay, you need to determine if the business has a realistic probability of survival. Okay, I had a colleague of mine for whom I worked with for many years, who used to use a term, it's like pushing a wet noodle. Try to push a wet noodle to see where it goes. Okay, so you got to understand what is the probability of the survival of the business. Okay, and knowing that, you can then negotiate, okay, what is a place that you can move forward. Landlords might be amicable to a realistic proposal if they can see the business will survive. EDC, SBDC advisor can help you prepare for that. For example, it is costly and time-consuming for a landlord to have to go through an eviction process. I did real estate lending for a number of years, and I was involved with evictions. I was involved with the pains that the landlord needed to go through and how much effort they put in to avoid having to go through an eviction. It's not fun for them either. And I'm sure there are some landlords in this group here today, they probably can relate to that. So keep that, and the plan has to be realistic. Consult with someone to see if the plan is realistic and if the timetable is acceptable to the landlord and to you as a business owner. I'm through, Claire.
Thank you, Gonzalo and Tony. Okay, we are going to move into our panel discussion. And I just want to clarify, we have a few questions that I'm going to be asking our panel today, all of which are able to answer. This will take a few minutes, and then we'll move into Q&A. So hold off for a moment on the Q&A until we get through panel just in case the question that you may have in your mind is answered. So first question to anyone who would like to answer is, what have some successful businesses done to survive the pandemic?
I can tell you that they have made significant adjustments to their financial position. In some cases, they have to make payroll adjustments. They look at the large expenses. And so they have to tighten the belt in order to face reality. And reality is dependent what happened to sales and what happened to my pricing.
So to follow up on that, we also have clients who have fundamentally changed their operations and capitalized on profitable organizational structure and set aside things that were costly and weren't necessarily making them money. Goes back to this idea of cash is what pays the rent, not paper profit.
Some have changed, made changes by selling segments of their business, focusing on the more profitable segments and disposing or selling the less profitable into segments of the business.
And some have been open to change and opening to pivoting. We often talk to clients who just don't want to change and they want to keep the same business that they've had before and believe that they can't change. And the successful ones that we've seen have seen how this pandemic has changed every couple of months. You have to do something else. And so the successful ones that we've seen advising are the ones that are open to change and pivot. Going online was something new for a lot of them, offering services online, learning technology, really being open to change as a constant thing and being open to do something different to keep their business successful.
Thank you,
Another
everyone.
thing
Go ahead, Tony.
Another thing that unfortunately some businesses have done out of necessity is, in order to stop the bleeding, have actually shut down their business. Mm-hmm. It's one of those. It's what perhaps the last thing a business owner would wants to do, but the group here, we've assisted and had consults with a number of businesses that have navigated through those steps as well.
Thank you, Tony. And I think the overall theme, at least for the answer of question number one, is to look at the spectrum of options and to remain open to all of those options. At least in the businesses that I've worked with, that has been the openness, the level of openness. Creating a mindset toward openness is also incredibly helpful in order to make those business model pivots that we've seen so many businesses do. Question number two, what are some considerations for commercial tenants who find themselves at a crossroads in their business? We've touched on some of them, but what would some of you identify as maybe the top two considerations?
Well, we're back to that idea of you begin with putting everything on the table and contextualizing it relative to where you are right now in today. Businesses that have been successful are willing to let past operations, past sunk costs, let them go, minimize their costs, minimize their exposure, and then use that entrepreneurial spirit that you're talking about, Claire, to pivot, reopen, in some cases completely rejigger what they're doing as core business. So acknowledge the crossroads and then move across the crossroads, not just be sitting there watching the river rise.
Keep in mind, if you have a proactive approach to your business, it's time perhaps for reinvention of the business. Do things a little bit different. Case in point, some restaurants that are now doing better with takeout services than they were doing at the prior year, and they have done very well. Other people that have created new products, they went outside and found out, what else can I do with the machine tool manufacturing plant that is right now working at 50% capacity. So you need to think. You cannot just sit back And remember that behind every crisis, there is an opportunity. God knows we have a crisis. Find the opportunity for you.
Yeah, that's really good. And I would say it speaks to, I was talking with a jewelry designer who has a storefront, and she sold through Etsy as well. So she already did sell online, but because people couldn't come into her business, she started selling more on Instagram. And she told me she never wanted to go in that direction. It wasn't anything she wanted to do. And so again, that's another example of someone having to change their mindset. But what that has created for her is a global business, where before it was entirely local. And so she is known now around the world for the jewelry that she sells. And it's created an incredible pathway for profit for her. So it's been great, and speaks to what you all are saying as well. So question number 3, what are some options for commercial tenants who must close their business?
One possibility is subleasing the space potentially if it's a space in demand, and to consider subletting, provided the lease allows that.
And go ahead, Bill.
Well, and closing a business is, when you close something, it creates the potential for opportunity. So one of the challenges is people who say, I have to close my business. And then the deeper dive is, there are other ways to do the core business that I have, and the current organizational structure is not viable anymore. So it's really 2 processes. One is to say, make the decision to close, go through that process, and then look at the opportunities that come out of that.
And if you literally have to close, if you're a corporation, this is a side issue, but make sure you follow your corporate formalities, right? There may be some, especially if you have multiple owners, you may need to do some type of vote. There may need to be, if you're really shutting down an entity, you may need to file a termination and cancellation with the state. Just make sure you look at your bylaws or your operating agreement and follow the formalities for closing, if you actually are shutting it down and ending and terminating the entity.
I hope that before you reach that decision, you explore the probabilities of merger or sale of the business. There is individuals, they're your competitors that might be interested. You have something very valuable, which is your customer base, okay? And you have employees that are very valuable. Talk to someone. Getting 50 cents out of a business is better than shutting down everything. So keep that in mind as well.
I encourage you to meet with, set up an appointment with an EDC, SBDC business advisor. We're here to help you map out plans going forward.
All excellent points. Thank you. Last question before we open it up to public questions. What are some legal considerations for commercial tenants to think about? And we've talked a lot about this, but maybe if we can stick to the high level, what are some legal considerations for commercial tenants to think about, maybe as it relates to eviction or the topic as discussed?
Well, obviously there's the unlawful detainer action. You may have to hire legal counsel to help you respond to that action, and possible liability under the contract. There's also your other vendors. If you are not performing other agreements, there may be some liability with other vendors, and you may need to negotiate with others, not just your landlord. And there are other, one important thing is, can you sell off your personal property in your business? If you have an idle loan, for example, many of the personal property items, the loan is secured by your personal property. And with a couple of tenants, I've actually checked, and the SBA has filed what's called a UCC financing statement with the Secretary of State, which gives public notice that those assets, the loan is secured by those assets. So before you decide to, if you have an idle loan that's of a certain amount, you know, before you decide to sell off all your personal property, maybe to make lease payments or satisfy vendors, you might want to just have a quick discussion with legal counsel, whether or not those assets are secured, and the effect of selling off assets that you've secured under an idle loan. And there's also other possible options, right? There's, we hate to raise this, but if there's liability mounting on all fronts, you may want to consider bankruptcy and having the discussion with a bankruptcy attorney whether bankruptcy would be an option, especially if you have a personal guarantee that's risking certain personal assets. That may be a discussion that you might want to have.
Thank you. Any other considerations before we move into full questions? No. Okay. Okay, so we are moving into questions now for all participants. I would encourage you to use the Q&A feature at the bottom or top of your screen. It's at the top of my screen. Please enter your questions there and I will read them off to our panel. I'm going to stop sharing the presentation and we'll go back to it at the end. I just want to mention a couple things. We will not be addressing specific eviction moratorium issues as it relates to your specific location within the county or city for two reasons. One, it's a very nuanced and complicated, it can be very complicated answer to discuss live, and also because of this recent extension to the eviction moratorium that the state has generously given and confused us all. So that's why we will not be doing it. But other than that, I will start with the Q&A that is already here. And again, please do not hesitate to ask questions. You can call and make an appointment after this panel presentation. And we'll just go through the first one. So Patrick is asking, and again, these are some questions we will not be able to answer live, and I just want to set that expectation ahead of time. But to the group, Patrick is asking, why did the city terminate the commercial TEMO program? Considering a third mandatory business closure ensued, why did they not provide help? Our landlord refused to negotiate and we barely made it. I don't know what city you live in, Patrick. But he goes on to say, our landlord is insisting we sign a confidentiality agreement now. We have 14 years left on our lease, 4 years plus 2 5-year options. It indemnifies them and places us in default if we discuss any terms of our lease or any binding agreements. I want to decline as it poses only risk with no reward. Can I decline the request? Is this a question we can answer live, panel, or?
Well, I think we should be careful about answering that specific because he has a very specific dispute. If you may want to have a chat with legal counsel, and I would recommend before you sign any document, always having a lawyer review it to compare the rights and restrictions in that document versus any eviction moratorium rights and protections that you have. So you've got some very specific terms that your landlord has presented to you, how they affect your lease versus your current lease terms and the eviction moratorium. Someone may want to do an assessment. So although we could maybe have some discussion with you as advisors, we can't give you legal advice, and you may still want to talk with a lawyer. If you're going to agree to anything or revise anything, you may want to have a lawyer looking at that document to make sure they give you your legal options and the effect of signing that document.
So if the original lease goes silent with respect to confidentiality, this is a new negotiation. What would the additional consideration be? So
there's some contract law issues there when you do amendments. There's and we can't get into the for purposes of this, but there's usually some type of tit for tat. So someone would have to look at all the clauses and see, if there's a tit for tat, and what are you giving up, right?
Absolutely.
What does the confidentiality restrict you? Does it restrict you from talking to whom about what, and how does that affect you long term? So there's definitely some legal issues running through that you might want to have a discussion with someone on.
I find it really helpful to have those clauses on separate sheets of paper so that they just as plain language, you can identify what they're saying and how they're saying it, and try to strip away the legalese, make it very basic language before you enter into a dialogue with an attorney, because you want the attorney to be able to support your position. So get clear about what you believe it to say.
And very often confidentiality clauses have exceptions, right? So they'll say, except you can talk with your advisor, your CPA, your lawyer, right? How literal is the confidentiality clause, right? And so that's important. It's also important when you're talking with any of us, do you have any confidentiality clauses in any of your documents to make sure that there's either an exception or something that allows you to share and discuss documents with us, right? So if you want to have sessions with us, check your documents and make sure you're not under any restrictions. We certainly don't want you to be breaching your contract with talking to us.
Thank you. I'm going to move on for sake of time. We have 11 more questions or 12 more questions. The second is, our tenant is claiming hardship and only paying 25% per ordinance. We do have a personal guarantee from our tenant and have asked him to share with us and the amount they've received from PPP and SBA loans, but they will not do that and have decided to spend it in other ways instead of paying the full amount of rent. What options do we have as a landlord? Great question.
Well, we're back to Erica, what you've been saying and what I've been saying. It's specific to the agreement that you have with the lease. Look at the other areas not specific to lease. What are your other remedies? It's really easy to get blinders on and look at one clause here. Look at the lease in total.
And sometimes if under an eviction moratorium, a tenant may be not in breach, that doesn't necessarily mean you can reach the guarantor, right? There has to be a reason that the breach has not been remedied, or they can sometimes just go to the guarantor directly. So it's really going to depend, is there an event that allows the guarantor to be reached in the first place, right? And it depends. I don't know if the guarantor could be liable just by the tenant's failure to provide information and documents. That's a really specific, narrow question. And so I think we need more information.
I would encourage you to call and make an appointment with Erica specifically on this one.
You will not get legal advice.
She will
Yeah.
help guide as much as possible.
give
Thank
you-
you so much for that very important question. The next one is about the current state or Santa Barbara County ordinances, late rent payment penalties. We said we wouldn't go over that, but Erica, is there a resource that you can direct them to beyond the county's website?
NOLO, and we think we have it in our resources. NOLO.com has been kind of keeping track and trying to update. They don't update all of them. I've been keeping track as best I can and checking now. I mean, one of the things that we do have to check, sometimes toward the end of a moratorium, maybe a week or two or three before, a city council or a board of supervisors or a health officer will issue a new or amended order. So it's really good to check now that we've had a new one. Are the cities going to amend any of those? I've been keeping track pretty closely. So if they have a particular question, they can give me a call and I can look at what my chart and then go quickly look and see if there's a new ordinance and try to give them this as current information as I can find. I can't give them a legal opinion, but I can try to find how current is it and see if my last thing, if they've updated it since the last moratorium that they've had.
Thank you. So there's the NOLA website listed in the chat. You can check that out. And as Erica said, with this new moratorium issued by extension, these things are subject to change.
Right.
So
Right.
please.
And some of the local moratoriums say it starts this day and it ends this day. However, if the city council or if the governor extends it, our end date will be extended. So some of these are automatically extended by Newsom's new order. And so we can kind of look at and see if there's an automatic extension. On the balance, you do need to think about how much back rent do you want to collect, right, over time, because it could end up being a huge amount. And so you really need to think about negotiating that and not just sitting back and not paying rent, because you could end up after 6 or 8 months or a year, as long as these moratoriums have been in effect, a huge back rent balance. And so when the moratoriums end, the next month you've got to pay current rent, right? So some of the moratoriums allow you to have certain time after it's ending to pay, but some don't. So you've got to always have that assessment of what's that unpaid balance that's accruing.
I hope that everyone can see how nuanced and layered these answers can be. It's not easy to give a yes or no answer. So I would encourage everyone who needs assistance to call us, and I will go over that number at the end. But just for sake of time, we'll move forward. The next question, my landlord gave me a document saying I need to pay all of my overdue rent in 5 days or he's terminating the lease. Can he legally do that now? And really, Daphne, it depends on where you are. I'll let the rest of the panel speak to this.
So later on, Daphne says she's in Thousand Oaks. Thousand Oaks doesn't have a moratorium. And the governor, I want to go back to the very specific language of the governor's declaration. It gives local jurisdiction the ability to have moratorium. Thousand Oaks, for whatever political reasons, has chosen not to do that. So it's a very unique thing. And Daphne, it really is something that we would need to talk to specifically and look at the total of what you're working with here.
I think the moratorium, I believe it ended in November, and I think it did have some months after the end to pay back rent. So it just depends on where you are. Are they talking about back rent or current? So, maybe give us a call. We'll try to, assess what their moratorium says and where you are as best we can from a business point of view.
Thank you. I have next question. I have been able to pay 50% of rent due since COVID. This total is getting pretty high. Are there any legislative plans available to give landlords rent reimbursement to apply to businesses rent due, such as mine, heavily affected due to long-term closures, personal services? Okay, such as the 80% reimbursement, 20% abatement, provided payment is in full going forward. Okay, there's a lot to unpack here.
Right.
My first question is to this individual, if they had applied for PPP. There's multiple financial options, but go ahead, whoever wants to take the lead.
You got this one, Erica.
I haven't heard anything on the commercial side. I mean, I know there's some certain local programs on the residential renter side that I think either gives rent to the landlord or to the tenant. I think it's LA County has something. I haven't heard anything on the commercial side. They're mostly residential. I don't know. Has anybody else heard anything?
No.
No.
Definitely give a call. There's a lot to unpack here.
Yes, definitely. Okay, we're going to move on to the next question. I've been communicating with my landlord to negotiate rent changes on a month-by-month basis. Excellent. Gold star. He has been very flexible so far. That's amazing. The pandemic is forcing rental rates down everywhere. So I hope that once things are settled down, that I don't have to go back to paying the full amount for my lease agreement. Looking into your crystal ball, wouldn't that be amazing? When will it be the right time to permanently renegotiate the lease? That's a really great question.
I would I would pose the question to the landlord. You're already in communication, and to Gonzalo's point, your win may be a loss for the landlord the way you've currently framed it. So that may not be seen as something that can occur. If it's
Ask the landlord that same questions. Where do you see your plans going with this particular property? Because it's going to be a supply and demand situation by the time everything gets back to semi-normal. I don't think we're going to see full normal for a while, but semi-normal. And he may give you an idea that he's going to sit and wait because he's going to get some money. On the other hand, I doubt it. Okay, because there is going to be a supply greater than the demand for a while. So he may be willing, or she may be willing to negotiate right now. And
Phil, do you know, is there any information or data out there as to what percent rents are going down based on the decline?
well, there's narrative, but frankly, it's going to be place, time, position. This is about relationship between the tenant and the landlord. And I don't know. It seems like, to Gonzalo's point, have the discussion.
yeah,
If the landlord is going to somehow look for the bottom or time it, then that's honesty on the part of the relationship. More than that, it's crystal ball time.
And I would recommend, obviously, if you haven't done so, doing the financial assessment and projection so that you can, when you're talking with the landlord, you know where you are, and you can say, well, here's where I think my business is going. Here's, kind of where my finances are going. This might be their best route. And maybe we can have some things that have escalation based on where my business is going up or down in the lease. A rent changes based on where your business is, at least for a certain amount of time. So,
Yeah, so say if the revenue has gone down by, say, 50%, how flexible do you think a landlord would be with possibly reducing the rent by 35, 40% going forward?
given that the supply is going to be larger than the demand, okay, and if you have the right business proposition in front of the conversation with the landlord, okay, you may have a good opportunity. If it's not, again, using the same premises, supply greater than demand, you may find another property for the price that you are willing to pay that replaces what you have right now. And I tell you, the landlord will move if he's or she sees that opportunity.
Right. Well, I've in some shopping centers where there's multiple spots, sometimes a landlord will allow a tenant, like you said, Gonzalo, to downsize and move where it's a better likelihood that the tenant will be successful because the rent is cheaper. And some landlords, there's prospective tenants who want that spot. So it's a win-win for everyone. And if the landlord is too aggressive with the tenant and the tenant sees that everything's going to fold, you could be pushing a tenant into bankruptcy and then nobody's going to get anything, right? You're going to be subject to a stay. So even if the moratoriums are lifted, once you're in bankruptcy, there's a stay the creditors can't pursue, and you might be getting pennies on the dollar. So it's always a good balance, right? Landlords have to be thinking about what the tenants could end up being, and the tenants have to think about where they're heading to. It's a balance.
What steps do you think the landlords are taking with their lenders? I wonder if anyone wants to talk about that.
The lender, Tony, is already talking to the landlord, and the lender is trying to set up some kind of restructure of the debt to accommodate what's going on. That's my assumption. If for a lender that is looking at a positive outcome of the whole thing. So the lender is doing that already. So the landlord knows what the lender is willing to do, but the landlord is going to have to bring back some facts to say, here, tenant A, B, C, and D this is what I have in my hands. Help me work with this. And the lender will help me work with that, because the lenders are also getting pressure from the government authorities to say, help the landlords. We do not want loan losses that are going to be horrible for the banking or the lending industry to face. So everybody is willing to compromise, provided that there is communication and there is a realistic plan in front of them. Okay, so keep that in mind. The lender is not sitting there by himself, not willing to compromise. They're willing to compromise, I strongly suspect. And the ones that are not, I don't know that they're going to survive much.
You know, Gonzalo, it really depends on who the landlord is, because sometimes we've got local, small, small business owners or medium-sized, but some of the landlords have been, I don't know, investment-based, right?
Yeah,
LLCs
yeah.
out of state, and they don't know the eviction moratorium laws. They are flush with cash, and they're not having that real financial issue that maybe some of the more local ones are. So sometimes they're less willing to negotiate. I found the bigger ones are more open. Maybe the smaller ones who are really depending on the rent to survive are less willing. So knowing who your landlord is, are they an entity that's local, that's maybe understanding your issues, or are they some out-of-state LLC that has a property manager? Or are they negotiating from out of state? They really don't know what's going on here. That could make the difference in how the negotiation is going.
That's
Have
what I
you seen
mentioned
any
in my
tax
presentation.
incentives offered by the federal or state level? No?
Thank you. I'm gonna move to the next question. I think, Tony, this is a little bit of what you're asking. Are there any state or local relief programs that will mandate renegotiation with the landlord? I'm not aware of any. Does anyone? No, I think the answer is no.
It would be great to see some movement there, right?
Yeah, it would be, and it's something potentially we could try and advocate for. So Stephanie Harrison, I did see your chat. We won't get into that, but what her question is, what do you do if a new business has not opened? It was under construction and struggling with closures and capacity because she has a hair salon. And I think that goes back to what we've been talking about, renegotiating with the landlord. I don't know, would anyone else like to add to what has been said about this already?
Well, the landlord already has an investment in tenant improvements for this location. So you need to, again, we go back to the same thing we've been talking about. Sit down and negotiate, find out what the landlord is. Okay. And so.
Well, and Gonzalo, also looking at the financial condition of the business that never opened, are the stressors so high that the survival of this new business is going to make it in this open close environment that we've lived in and may still be living in for a while.
Yeah.
So part of this is that hard look on that side.
So Stephanie, I see your last question. I'm jumping down a little bit just to add to her challenge. Before I read this, I'm going to suggest, Stephanie, that you schedule an appointment to meet with one of our advisors, because this is very specific. But she's asking, she has a new business that did not qualify for PPP or grants due to the lack of tax returns from last year. All monies were placed into renovations, and now she's struggling with closures. Will there be some help for those businesses? I'm currently behind on 2 months paid taxes, something and trash, hoping to negotiate lower terms, but I already put all that I have borrowed into renovating the space. So I'm going to suggest, Stephanie, that you reach out at the end and try and schedule an appointment with our center. I appreciate all that you've shared. So we have about 5 questions left and 15 minutes. So I'd like to get through as many as we can. The next one from Joby is, do you recommend requesting a meeting directly with the property owner when there is a property management company in place? Great question.
Well, that's what I mentioned before. You need to know who is the decision-making entity in the organization. Sometimes the property manager, the local property manager, do not have authority to make this decision. And I've been involved with those. Okay, so you got to know where the decision making is in the landlord organization. It may not be the head of the firm, like Erica indicated. Some of these LLC or real estate company, they have multi-layers, but they got to be somebody above the property manager who can make local decisions. So you need to find that entity.
Mhm.
The true owner may not want to speak with you, right?
That's right.
They may not want to talk with and they may say, okay, communications have to go through this property manager. So it would be nice if you could speak with the landlord, but that may not be the channel that you get of communication that you get to have. So it just depends, right?
Many companies in that regard, Erica, they have a landlord dispute supervisor. Okay, they might use different names, but because they're often disputes, not necessarily like the one we have right now, but all the kinds of dispute. So that person normally has a great deal of authority. So you may want to reach that level if the property manager is not the one.
Okay, let's, we actually only have 2 other questions up here. I'm removing your question because it's not a question, it's more of a comment. Thank you. I want to get through the last 2 and then get into additional resources. So Varon says, my lease just expired. Management company gave me a 20% increase and further 3% for every year for the next 3 years, bringing the increase to 29% in 3 years in this pandemic. I have been there 25 years. How can I talk directly to the business owners because I can't get a hold of them? If you can't take this question in public, please help me after this meeting. So again, please call our center. Please call our center, and I'm gonna send you the information now. That you can...
Yeah, I know there were some limits on residential increases. I can't remember off the top of my head if there's anything similar to commercial. We have to look around a little bit, but I know there were some caps and statutes on increasing residential. I just can't remember if there's anything on commercial.
Okay.
I guess probably not, but we can take a look.
Last question, and it's a good question. Do you know of any examples of how landlords have helped out commercial tenants? Do we have any good landlords out there who've helped out commercial tenants?
Yeah. I've heard some that have abated the rent for a few months so the tenant could get on their feet. The tenant didn't have any money, like the hair salons or the massage parlors, they're 100% closed down. So the landlord tries to work with them and says, I'm not going to charge you rent during this time. Or they do an escalation. So if you've got 20% of your business back, they charge 20%. If you get 50%, it goes up to 50%. They stretch the back rent payment out. They reduce the rent for a certain amount of time or for their end of the lease. They put the back payment on the end of the lease, so maybe they add a couple of years on the end of the lease. There's so many different creative ways to negotiate if the tenant wants to stay in business. I've heard so many different things.
Yeah.
We have a situation where the landlord, the business is now resuming a fair amount of activity, okay, and the landlord was willing to take a note on the back rent. So that means rent started today. So he took a note on the back rent and is payable a certain interest rate on a percentage of profit. But in that case, the tenant has agreed to share financial information, okay, which is the only way it was going to work. It was not going to be just a one-way street, but that is a very amicable solution that is a win-win for everyone. But again, it came out of a lot of conversations back and forth. And so what we said to you throughout the presentation, communicate, present a logical plan, be willing to compromise, and I think it could take you a long way.
Can I piggyback on one thing, Gonzalo, you and I have talked about is documenting every aspect of conversations from the minute you start talking with your landlord. document the name, date, place, time, what was said, and then consider confirming it with an email so you have a really good document trail, because some
Wonderful.
landlords will orally promise something and then change and flip, or tenants too, right?
Yeah.
This is not an indictment of landlords, you know, it really isn't. But sometimes people forget what they've said, or things have changed in negotiations. So you need to keep a very good written or electronic ledger of the communications you've had, the who, what, when, because sometimes we talk with clients and say, okay, who said that? I don't remember. I think it was a property manager. Well, who at the property manager promised you could say that? And they can't remember, right? I mean, I'm getting old. I can't remember what happened 10 minutes ago. So especially when you're emotional, you really may not remember. You just may hear what you wanted to hear. So keep an excellent documentation of the name, the time, the person you spoke with. If you can get their contact information, if you don't have it, and then maybe consider confirming the discussion via email. Just something to think about.
Thank you, Erica, and thank you everyone on the panel. I really appreciate it. I'm going to run through our additional resources to close out our meeting today. Bill mentioned the importance of emotional capacity and how much we're actually focused on that during these moments. And we know now that we've worked with so many different business owners, over 14,000, and even in our own life, how important mental health is. And so I would recommend checking out wellnesseveryday.org. They do provide mental health services. If you do not have access to a counselor or a trusted friend or advisor, please check that out. There is hope in getting through these moments, and especially in working with, this is for Ventura and Santa Barbara County, by the way, in working with people who have gone through traumatic events. And this has been a collective and corporate trauma. So please don't discount yourself or how you're feeling. For legal resources, we have the Ventura County Bar Association, the American Bar Association, the University of Southern California Small Business Clinic, and don't worry about writing these down because I'm going to be emailing them to you. Right. This presentation as well. LA Represents, with specifically for LA County, and Justia Resource. So you can access all of those small business clinics, information on COVID, landlord, tenant negotiations, and those types of resources there. We, of course, are the EDC SBDC, the Economic Development Small Business Development Center, and we have no cost consulting services available. Like I said, we've worked with over 14,000 businesses since March of last year. If you haven't called us, you can do it today. And 409-9159 is the number. We have resources available in Spanish and English, and all of our services are at no cost to you. You have been introduced to 4, technically 5, if you count me, advisors of a team of over 40 now, expert advisors in every area of business need. So please call us today and schedule an appointment. For additional resources for financing, we have our EDC Disaster Loan Fund, and we manage 5 different loan funds actually. So please check out our website to see what loan fund might work for you. But for disaster and disruption, we offer a $5,000 to $50,000 loan fund at 4.25% interest over 48 months. So it's a great loan fund to check out. And then Women's Economic Ventures, one of our partners, one of our SBA partners, has a quick response loan up to $10,000. And I think they're actually calling this now their restart loan. So apologies on that, Weave, if you're listening. But up to $10,000 is what they're offering at 4.5%. So visit them. They also have a great entrepreneurial program available. Again, for no cost consulting, here are the numbers. It's been in the chat multiple times. 409-9159 for English, or 309-5874 for Spanish. Our business loan number is 409-9497, or you can visit our website, edcollaborative.com, and we have a special page dedicated to COVID-19 resources there. And don't worry about memorizing any of this. It has been recorded. It will be shared with you shortly. We appreciate all of you for attending, and we wish you the best of luck in your journey and your business ventures, and best of success. Any last words from our panel? Deep breath. Deep breath.
You said it all. You said it well.
Okay. Well, thank you everyone for attending. I will leave you to the rest of your afternoon. Have a great day, and we'll be in touch soon.